all about Clickwrap agreements here for about 6 years. All I have done kind of for the entirety of my career. And then Nicole is our product counsel here at PackSafe. And so really her and I have really, Nicole, I guess, this is the one area of law, and this is the one area of law, legal operations, whatever it is in-house, where probably it's not a brag for me, because I still joke that I'm a walking malpractice suit if I were ever to go back and practice. But the one area that you and I have probably spent most of our career, and probably know more than most when it comes around TOS, terms of service, and click-through agreements and things of that nature.
Yeah, definitely agree. This is an area of the law that we're not taught in law school, and most attorneys, the only attorneys that are going to encounter this are in-house attorneys, and most of them do not care about it until it's, you know, a fire on their doorstep and they're involved in some sort of litigation or, you know, something not so good.
Yeah, so today's session, what we'll be going through is a little bit of an overview on the Robinhood Saga. I'm sure everyone's kind of followed along in the news, but what we're going to talk through is how terms and conditions and terms of service, a contract that we all think is pretty forgettable, and maybe you as a legal operations professional, it's not even something that's on your radar or on your roadmap. We'll talk a little bit about the mechanics that a lot of people don't think about with the litigation that's emerged after the GameStop saga here for Robinhood, and how TOS will end up becoming a first line of defense to deal with those class actions or other types of disputes that may be bubbling up. And once we've talked through those two first items, we'll talk a little bit about what we do here at PackSafe and why what we call a CTP should likely be a roadmap item for you in legal operations, even if you're a B2B company. Most people think about, you know, hey, TOS, terms and conditions, Clickwrap or click-through agreements as something that's reserved for those consumer apps that we all use in our day-to-day lives every day, whether it's Robinhood or Uber or something of that nature. But this is something that we actually see that stretches to any sort of digital business, and we'll talk a little bit about that later on in today's presentation. So without further ado, we'll go ahead and dive in. And today, how this will work is I'm kind of going to lead us through the discussion. Nicole's going to hop in at various points. Please do ask us questions throughout. We're happy to answer questions that you post in the chat, or we'll also reserve some time afterward. But zooming out a little bit, I think everybody kind of knows what happened. Geez, Nicole, we did one of these last week, and then I think then I said it was about 2 weeks ago, I guess now 3 to 4 weeks ago at the end of January, when the news was dominated by GameStop and Robinhood, right?
Yep, just about a month. We're coming up on a month.
Yeah, and I think at this point, everybody knows what happens, right? Robinhood froze trading on GameStop stock after a bunch of folks from Reddit were juicing the stock. People were making money, and then all of a sudden, they couldn't get in to make their trades. And obviously, it's an extreme example of a dispute that bubbles up into the public eye, and that all of a sudden, you know, Nicole and I made a joke about this, I think the week it happened. We don't get very many texts from, well, I don't get very many texts from my law school friends because everyone kind of knows what I do. So no one's asking me and reaching out about various other subject matter. But all of a sudden, this is the scenario in which Nicole and I get a bunch of texts from friends, because the question becomes oftentimes in the public's eye is, a company does something wrong or bad, or you know, pulls down GameStop stock, and the first thing everyone kind of that pops into their mind is, oh my God, the terms, Nicole, like, did our TOS actually allow for that? You know, they couldn't actually take that stock down. And I think it gets to something that you and I have talked about a lot, that everyone out in the public kind of distills disputes or issues into, you know, thinking TOS or this be all end all sort of agreement that grants everyone all rights to all sides of a transaction. And that's not really the case here.
Yeah, that's correct. People, I mean, you know, people's understanding of these kinds of terms is you're like signing your life away. You don't know what rights you're giving the company, and no one actually reads them. And so when something like this comes up, then they turn to the terms and they're like, wait a second, was the conduct that the company just engaged in actually allowed?
Yeah. And the thing that Nicole and I talk about is we try to bring people back to as we start talking about terms and conditions, terms of service, or any sort of click-through agreement in the consumer space and how we traditionally think of them. Let's level set on what terms actually do. Yes, it does govern the conduct between two parties. It's a private contract between consumer and provider. But what I can't tell you is whether or not, based upon terms of service alone and what's published on a site, is whether or not that Robinhood really had a right to do what they did. I can tell you what terms say, but I think it's always important for us to reiterate, and especially talking about any sort of controversial topic, there are all sorts of items that can supersede a private contract, Nicole, as you and I know, and as any good attorney would know. Here in this situation, you can argue that there are breaches of duty and other items that stretch far and beyond what's in the set of terms. And I think it's always important to highlight a good piece of advice that I got early in my career, which is if two parties are looking at a contract and trying to decide what they can and can't do, we're probably not in a good situation to begin with.
Yeah, and to be clear, you can do a lot with a contract. You can't, if something's illegal, it's illegal. Even if the contract says you can do it, it's still illegal. So we don't really know how that's going to land with Robinhood, but what we can look at is what the term said and whether or not it's enforceable.
Yeah, and that often brings us, Nicole, to a conversation that is really what terms do and where terms come into play in lots of lawsuits, litigation, and things that go on, which is terms become a first line of defense for companies with whether they're able to prove acceptance or not. We'll talk more about that in just a second. That's a little bit of a teaser, but hey, let's give you the answer that you maybe came for. Was Robinhood's conduct allowed or not? Fine, we'll do the quick kind of coverage of this. Click into the TOS, yes. Robinhood does disclaim, like probably any other business that you interact with, they have a right to stop trading for whatsoever reason. There's an analysis out there. You can go to Reuters, you can go to a few other places that talk about this. The analysis ends here for a lot of people that are commenting on this dispute in the news. Nope, it's written in the terms of service, so therefore Robinhood's got a right. It doesn't start and stop just with what's in paragraph 16 within the Robinhood customer agreement there. It's not this simple, right, Nicole?
Nope, not at all. This, whether or not Section 16 kind of rules over their conduct really hinges on whether or not there's an enforceable contract in place. What happened when users were signing up, when they were agreeing to these terms? Did it form a binding contract? If it did, then maybe they're good with this. Maybe misconduct is still legal. We don't know. But yeah, that's where we're going.
Yeah, we won't tease that too far yet. But Nicole, if you haven't followed the Robinhood GameStop saga, you follow because of your job at PacSafe. You have to follow all of these cases that come out around consumer and Clickwrap litigation. You want to give everybody a little bit of an overview on what we've seen just in the last few weeks alone emerging and what types of claims the customers are making about what happened in this whole saga?
Yeah, of course. So what we're looking at here is since 2017, Robinhood's been involved in 81 cases. And this is everything. This isn't just consumers bringing suits, because of their conduct recently, but, over all time. And then 55 of those 81 cases have actually been filed in 2021 alone. And most of them were filed after, the whole Robinhood scandal about a month ago. And so of those 51 cases, the vast majority of them were related to them removing the GameStop stock and other stocks that were kind of also involved in that. And most of those cases are class actions. And so also what I'm seeing so far is Robinhood hasn't filed any sort of response other than asking for time extensions or asking to consolidate cases that are essentially alleging the same thing. And then if you're wondering what those cases are about, most common causes of action that we're seeing in these cases are breach of contract, breach of certain implied covenants of good faith and fair dealing, fiduciary duties, negligence, fraud, and then there's various violations of state laws kind of affecting consumers, consumer rights, that kind of stuff. And what these cases are looking for in terms of relief is injunctions, bringing the stocks back online, monetary damages. So they're wanting, whatever money they think they would have made on the stock had they been able to buy or sell when Robinhood sold it. They want to be compensated for what they missed out on.
Yeah. So Nicole, let's zoom back here for a little bit. And I know it's taken our slides a second to load, so bear with us a second. But what we talked about earlier, so this litigation arises, legal ops, obviously, many of you, I'm sure, are not on the front lines of class actions. But what do we know? Class actions cause lots of legal spend, lots of issues within the organization in terms of e-discovery, proving things out. This can become, for a certain type of organization, a major boondoggle within your entire legal operations function through your legal team larger wide. The first place that we have to knock these suits down and push them really out of the way is with TOS enforcement. But what a lot of organizations don't necessarily realize is what it takes to do that. And, really why TOS matters, if I'm going to back up half a second before we get into that, is, people what we don't think about is the arbitration clauses, the forum selection clauses, the class waivers. They're all procedural defenses that exist within TOS, and why they become so enforcement. And why for almost every lawsuit that has been filed, Robinhood's going to have to authenticate that their terms were enforceable. And it's going to be a point that smart plaintiffs attorneys, and Nicole and I are going to talk about what they do to get around those terms here in just a second. Smart plaintiffs attorneys are going to attack those terms, and they've gotten much more advanced in recent years in the ways those can become exploited, and then put your litigation team a little bit on the back foot in terms of fighting kind of this case. Nicole, I know this is something you see every day, and you read and you follow these motions.
Yeah, so really just want to reiterate a point that you just made, Kyle. Most of the time when we're seeing these kinds of cases come through the courts, they're not looking at enforcing any substantive terms. Like, it's all procedural. They want disputes resolved on their terms. They don't want class actions. They want arbitration. They don't want to go to court. They want to see people individually. So huge there. I think actually out of all of the 2020 cases in particular, I had a stat on this from something else that's coming out with PacSafe. Actually, it just came out this week, but I think about 90% of cases were arbitration. They're trying to compel arbitration. So that is, hugely valuable for defense there. Yeah, forum selection is one too, but arbitration is the biggest.
Yeah, so let's bring it back home for a second. So this is where we're starting to kind of dig into a little bit of the topic that we came to cover today, which is most legal orgs, when it comes to proving TOS acceptance, are in one of two scenarios. And this may be something you as a legal ops professional, I talk to and I work with folks that they know exactly what their team can do in this area. I talk to many legal ops folks that have never even thought about this area because it gets reserved and it gets siloed within litigation. They don't hear about it. Litigation doesn't know that there is a possible solution. It's a very, very niche problem that manifests within a certain group of people. It can be extremely painful. It can be extremely risky, but it never escalates beyond that silo. So this may be something you've heard of. It may be something you may need to go seek out and wonder, hey, what's happening over here? Because, hey, we all know litigators like to work in a little bit of a silo within the organization of your legal team. But one of two things tend to happen. Organizations, some of them have nothing here. They can't actually prove, if challenged, what a consumer accepted at really any given time. They can't come up with any sort of documentation to prove that. And then, of course, they either lose the case, the motion proceeds, the class action proceeds, whatever it may be. The other and probably more likely option for where most organizations are, from Nicole and I's experience, is it starts off the process of an engineering and discovery wild goose chase. A question that I often ask when I'm talking this topic to litigators directly is, how often is the last time that you talked to a back-end, if you work for a software company, for example, when was the last time you as a litigator talked to a back-end developer on your product? Doesn't happen very often, not a natural work stream. You may have an e-discovery team, you may have legal project managers or technical folks or database managers that can, find that information. But have you ever had to go to a developer and ask him to pull him or her or them to pull back-end information or back-end data logs and then match that up and reproduce source code to try to figure out what the login flow of your app looked like on March 4th, 2019. That's a very, very difficult exercise for a lot of organizations to replicate. And Nicole and I will talk through some of the pitfalls to that right now. Nicole, anything you want to add on either of those scenarios that we see commonly?
Yeah, so one thing to know about the second scenario is it costs a lot of time and it costs a lot of money. You're pulling people away from their day-to-day jobs to try and gather resources and documents to, prove terms enforceability. But it's a lot of time and money, and sometimes it's not even, you don't even make it in time.
Yeah. So what are some of those best practices that, organizations need? Nicole, this is your area, so I'm gonna look at you. There's 3 core areas, and I know you just actually wrote and released a new report on this that we update annually. On the types of evidence and what you need to have to enforce a Clickwrap agreement. Can you walk everybody through those 3 core areas?
Absolutely. So what we're looking at when we're deciding whether or not a Clickwrap is enforceable is you're going to look and see what the user saw when they were going through that contract agreement process, making sure that the screen put them on notice of the terms, gave them an opportunity to review the terms, that kind of stuff. You want to have a record detailing who agreed to what version of the contract, when they agreed, all of that kind of stuff. And then you're going to want to manage all the different versions of those terms that a specific user agreed to over time. So maybe the original contract they agreed to didn't have a couple of key provisions that you are now trying to enforce, but a modified terms did. And if you're not able to prove acceptance of the modified terms, then you're kind of going to be out of luck there.
Yeah, so let's click a little bit deeper into each of those areas. So the first thing that we need to prove when trying to establish our terms and conditions in a court of law is whether or not we put a user on actual or constructive notice. That includes, hey, basically, what the screen look like? What did someone see? And can you prove that I actually had an ample opportunity to review the terms if I wanted to? Nicole, this is a little bit of a tricky area because it comes down to when was the last time, let's flip the other work stream that I mentioned earlier on its head. Very rarely do litigators or legal teams worry about things like what conversion flows have to be or what the color of buttons in the app need to be. But those sorts of things matter when it comes to whether or not online agreements are enforceable in terms of a best practice.
Yeah, so this is huge. When we're thinking through actual and constructive notice, you're never really going to have actual notice because that's saying we know for a fact that this specific user definitely read through the terms. It's not usually how that works. So we're looking at constructive notice. Did the screen provide an adequate opportunity to review, that kind of thing? So we're looking at font colors. Is the font really hard to read against the background, or does it contrast well? Are the terms hyperlinked? If they are, does that hyperlink resemble a traditional blue and underlined hyperlink? Are users required to take a specific action to agree to the contract? Or is that agreement action kind of looped together with another action? That's what we call a sign and wrap. And that's where you're just alerting the user that by clicking sign up or log in or register, you're also agreeing to our terms. They're not actually required to take a separate action to agree. Is the screen uncluttered, or is there tons of links and language all over the screen that's kind of confusing and detracting the terms? Is it kind of being used as a tool to kind of get the user to not read the terms? Are they given an opportunity to review? Does the hyperlink work? Were they able to click it? Were the terms actually just embedded on the screen? Even better to do. So those are kind of some things we're looking at there when we're thinking through notice.
Yeah, and obviously, like the interesting thing about how organizations most often then try to establish that someone was put on notice is we have to then go get somehow a replication of what the screen at the time looked like. And the ways that Nicole and I have seen that solved are the most common one, I think, Nicole, that you and I see is companies actually go and use the Wayback Machine and try to figure out from the public source Wayback Machine,
Yeah.
hey, what did our page look like or my login screen look like on May 28th, 2019? That's a pretty not exactly a foolproof exercise, right?
Yeah, it's not the best idea just because it's not always super reliable and the archivists don't really want to help out. It's not really the purpose of the Wayback Machine is not to help in legal disputes, and they don't like being used that way. Another thing we see is engineers will go back in time and reverse engineer what the screen looked like and replicate it that way. Sometimes they'll just happen to have screenshots. It doesn't usually happen very often, but even then, if you have screenshots and you're not able to prove or show what date range the screen was active in, it's kind of a useless screenshot. But yeah, there's various different ways, but screenshots are probably the best evidence that you can use here.
Yeah, so moving on to kind of the second area that becomes really important, it's what was actually live behind the link. This is one that a lot of teams and a lot of folks that work on Clickwrap agreements don't even think about. We take and we know, hey, we have to put the user on active consent, or excuse me, active or constructive notice, sorry. But the thing that we often don't think about is the connection between the click action and actually what those terms are behind the screen. So the majority of Clickwrap agreements that we all accept today, out in these ecosystems, either as personal individuals or working on behalf of an organization, we check that box, and then to the right, someone's written, I agree, by checking a box or by taking this action, I agree to a certain set of terms. We've had this slide for a long time, and this Dropbox one just makes it pretty obvious. I actually don't know anything about their processes behind the scenes here. But one thing that you need to be thinking about is, let's take a real life example. How would you be able to prove that your terms were looked at by an individual, or maybe even how could you prove that Dropbox.com/terms wasn't down? That's something that most organizations, when you're thinking about legal processes, I don't think you're thinking about putting it like a status page object on your legal page, or making sure that that's always live, or making sure that the CMS or the content system that it's hooked up into, so that you can publish updates and your legal team can do that automatically by themselves, making sure that that's hooked up to the same system that's capturing the archiving of the actual click action. This is something, and not being able to match these two items up, that has actually cost organizations decisions. And it's one other way that plaintiffs' attorneys can exploit these Clickwrap terms, and will probably attempt to do so here in the Robinhood scenario, right, Nicole?
Yeah, and once an argument has been made on the plaintiff side that the terms were down, or the link was inactive, it's really hard to come back from that, because it's really hard to prove that it wasn't, unless you're actively tracking that the whole time.
Yeah, and most organizations, from our experience, do not have anything in place. What you can do, however, is use the same system that is managing the terms and managing the content, that is also tracking that and making sure there's what we call an immutable connection between the two, of what the actual version was and then what's actually storing the click acceptance and tying those together. And then finally, Nicole, this kind of brings us to the last one. This is actually what most organizations have, I think, in my personal view. Most everybody has some sort of metadata that we're able to produce, even if it's just like, hey, our terms are accepted upon the time of login. I can reproduce the IP address and the name of the individual that logged in at the time. Normally, people can get in the direction of this, but maybe we're not always capturing the full data footprint that we need to, in contrast with those other two items.
Yeah, that's correct. A lot of companies can produce at least a bare bones record, or they can have key employees testify under oath to the process that everyone has to go through, which includes terms acceptance upon signing in, logging in, that kind of stuff. But yeah, I mean, really, these records should be letting you know who signed, what contract, when they signed it, and how they signed it.
Yeah. So kind of stepping kind of further into this, this is kind of we've been talking about the Robinhood example, but if you remember from a few years back, the Ashley Madison data breach, this was actually a real ask from the judge and from the court in the Ashley Madison case of exactly what they were asked to reproduce in terms of enforcing their TOS and enforcing their Clickwrap agreement. Examples of the UI, documents sufficient to identify the time periods between what was active and live, differences between versions, demonstrating basically whether any record was made and record was viewed, and then also that individualized data we talked about. We've heard scenarios and horror stories of organizations having to mine into SQL databases and trying to look up, for example, Nicole, one that we've heard, all of the acceptances of a given set of terms between maybe 2019 and 2020, during an ongoing, basically trying to certify a class or something of that nature as part of that exercise. And they're just really, really awful and difficult exercises to try to go through that are pretty painful. That can be solved in a rather simple way. I know that most organizations, this is not the first thing you think about when you build a legal operations roadmap, but it can often be one thing that, hey, we can just, instead of, having to tolerate this risk or tolerate this problem, with a really simple and easy fix, we can make sure we don't have to worry about this and we're prepared. So a quick plug before we transition kind of into the second part of today's session. If you're interested in, or you've got someone on your team that's interested in, hey, are we at risk for being Robinhooded, or any of these other sort of scenarios that you heard here today, we actually have an exercise that is enforceability readiness assessment at PaxSafe, where we will give you an exercise that you can just email. We'll keep it simple. You don't have to go download anything, so you get marketing content. Just email me, Kyle@paxsafe.com, with a subject line fire drill, and we'll send you over an exercise that you can share with your team. Make sure you're actually able to pull together the information and the basically the evidence that you need to enforce a Clickwrap transaction if you have them throughout your business. And Nicole and I will actually read through it, flip through your answers, and give you feedback on, hey, here's what's missing, here's where you might want to click a little bit deeper, and maybe run one more scenario with your team. And we're happy to do that. We do that for a lot of folks, free of charge, no service to that, or just something that we do to try to help educate folks on this issue. So as we transition a little bit, Nicole and I are not, we're not naive in the sense that, we focus on Clickwrap agreements, and we like to champion this cause, and we like to raise awareness to it. And I've been doing this for about 6 years, having these conversations. Nicole's been doing them for about probably two or three or so. Not lost on us that the first thing that comes to a legal operations individual's mind is not, hey, I need to buy a Clickwrap transaction platform to solve this issue. But what it can be is it can be a tool in your toolkit as your organization evolves, and there's a specific reason for that. The slide here got a little bit messed up as we loaded, I think, them into the system, but the reason often for that, and why we see companies coming to PaxSafe today, is that really every business in some way is what I'm going to call Robinhooding. Not that you're trying to trade, trade stocks online or something of that nature, but almost every type of company wants to become something more like a tech company. Whether you're already digital and you're a customer of ours like DoorDash here at PaxSafe that leverages our platform for all sorts of different things, but an evolving technology company like someone like F5 Networks that is acquiring and growing via acquisition. You're acquiring SaaS companies. You're starting to sell your product online for the very first time, or all of a sudden you need to govern and manage 5 or 6 different organizations or SaaS products that you've never had before. Or my favorite scenario to talk about, which is, the business that needs to evolve to stay relevant. And, we often work with organizations that are trying to go sell online for the first time, or completely blow up a human and document driven process to help revenue and business teams kind of stay relevant. And that's one thing that we've done at companies like Extra Space Storage, where we took a document oriented process for something like self-storage leasing, and we turned it into a completely self-service process online for all of those agreements. And it's something that I think we can all kind of see that as buying changes effectively. If you sat in last year on the presentation we gave with Kingsley Martin, we talked about low touch agreements and no touch agreements. We talked a lot about how the traditional playbook for contracting is breaking more and more as this shift toward product-led growth and all these buzzwords you might hear your executives talk about, product-led growth or sell while you sleep, sell online, whatever that might be. The document-based journey and the human-powered journey starts to break as part of that. And we've somehow got to reconcile how the legal team doesn't become the department of no, while the rest of the business is trying to change how you sell and change how you go to market. And that's where what we do here at PacSafe plugs in with what we call a Clickwrap Transaction Platform. Not here to just pitch our product, but the entire market space and why organizations find a need and why this is something we think that you should consider. It's not just the class action prevention that we talk about up front, but it's also how a platform like PacSafe can help you as a legal department drive more value through the organization by allowing you to come to business lines and business teams and say, hey, we can do business differently than we do it today, because now we have a platform that's able to work with this and work within the bounds of a web browser and work within the bounds of an app or product rather than just the four corners of a document. So most organizations, when thinking about PacSafe, often assume, hey, we're a B2C focused company. And what we do with Clickwrap agreements is only relevant if I'm a B2C organization. But that's certainly true. We work with companies like Wayfair that this exact Robinhood scenario, they came to us because they were experiencing litigation, experiencing issues trying to enforce those TOS. But if you're any sort of other different company, there's also uses for our platform and for our product, and where things like Clickwrap agreements can fit in. I would strongly plug and recommend our the webinar that I mentioned earlier last year that we ran with Colin on self-service and no-touch agreements and how Clickwrap agreements can actually cut down on negotiation. We have folks like CDW that leverage our platform to help them actually cut down red lines and cut down cycle times within their contracting processes. And there's real measurable time savings. I won't read the slides because I hate when people do that too. But here at the bottom of the screen, it talks a little bit about that and what we do here at PacSafe. But it's a real tool that you can utilize to actually evolve your organization and become a change agent. And this can sit alongside your CLM to help you address, this kind of world of online contracting that can be a real asset to everyone in the business beyond legal operations. But wanted to just kind of make a quick plug of that after we talk through kind of the Robinhood options. But Nicole and I are here for Q&A. We were about a runtime of about 35 minutes today instead of 40 like the last time Nicole and I did it. So we've gotten 5 minutes faster this time, but happy to stick around and answer questions here for about 5-10 minutes if there are any from the audience, or also happy to reach us at Kyle@PacSafe.com, Nicole at PacSafe.com if we can answer any questions for you via email. But Colin, we'll turn it back to you, and we're happy to answer questions from the audience.
Fabulous, Nicole. Fabulous, Kyle. I really appreciate this. Education refresh, and really like what you guys are doing. If anybody in the attendees has any questions, please let us know. One of the questions I had off the top of the bat, because I've used your product, right? Maybe it's almost 5 years ago now at Rubrik, and our use case was we were solving a sales ops problem for resellers agreements. Mm-hmm. And that was one use case. But one of the issues that kind of came up, I remember back then, was, hey, are these agreements enforceable? Can you talk about that?
Yeah, Colin. This is kind of the whole ethos of where we were trying to bring things full circle a little bit today. These conversations when it's really what I just talked about the legal department becoming the department of no that we all fear, right? You know, Clickwrap agreements are enforceable. Overwhelmingly, when it's done correctly, Nicole, I believe you just did the stats on this, and you can give it to us. I believe it's 100% enforceability rate, right?
Well, no. So I think we're looking at about a 70% enforceability rate. But to be clear, not everyone implements them correctly. If you're implementing them correctly, your success is almost but guaranteed. But there are mistakes people can make, like pre-checking the box or, using bad font colors. So it's really just integrating yourself with the design team or with the marketing team, whoever's designing the screen. And even if you just don't use our product, but you take our best practices to your marketing or design teams, whoever is in charge of the screen, you can very easily make an enforceable Clickwrap.
Wow. And then you guys mentioned, like you said, alongside CLM systems, do you have any kind of integrations as well where they can kind of run in tandem with your product?
Yeah, we do. So most users of PackSafe do not use PackSafe as a single home for their contracts or Clickwrap agreements or anything like a reseller agreement that you might be executing with PackSafe. So we pass back to most CLMs. PackSafe has an open API. We have to be an API forward product because of how we operate. So we integrate and have the ability to integrate with the majority of CLMs that have an API connection. Yep.
Is there any other further integrations with any other platforms other than CLM?
Generally today, CLMs are most common, but on the front end, we're obviously integrating with things like apps and websites and products where it's very, very important that we make it easy for the developers and product folks that you work with to integrate our product. So we have integrations, easy integrations on that side, like SDKs and JavaScript languages and really simple API programming formats. But I'll leave that talk for the other side of the organization.
So a couple more questions I have, but I'll jump into Jack's question and Christine's afterwards. Do you find courts are more willing to go around traditional contract law principles to invalidate Clickwrap agreements, or are they holding strict to the precedent?
That's a really good question. I've got thoughts on that, Nicole. I'm going to let you go first because you read more of the case law on a day-to-day basis.
So courts overwhelmingly are trying to apply traditional contract principles to online agreements. And so they really take that analysis. They're looking for offer acceptance consideration. And it's that acceptance piece that really is analyzed the most because, to accept a contract there's intent involved and that kind of thing. And so if you're kind of hiding the ball, you're kind of taking away that intent element. But, if you're making your screen conspicuous, intent's present. But a lot of courts will try and invalidate, but they do so by arguing, lack of choice, lack of, we're looking at contracts of adhesion or stuff like that. But the argument doesn't usually circle around branching away from traditional contract principles. They really do try and apply those in an online context.
Yeah, I know the one thing that I'll chime in there, Nicole, on that is if you remember a couple of years ago, I think something you and I followed was there was basically a nomination or a proposal to basically put in the UCC and adopt within the UCC that all Clickwrap agreements were going to be enforceable. That was really just absolutely went over horribly by most legal scholars, judges, and a lot of law professors. So that got rejected out of that UCC proposed amendment. So I would say, and I believe the argument, Nicole, at that time was assuming that a Clickwrap agreement is always enforceable does not follow common law contract law as to why most people were making that argument. So that's the first thing I thought of when I saw that question.
Yeah, that's it was like a draft restatement of consumer contracts. I've got a copy of it. Really interesting read if you're trying to build out an enforceable Clickwrap. It's a good starting point to understand kind of where the courts were, at least when that was drafted. But yeah, that didn't get good reviews.
Yeah, that did not go over well. Colin, you want to read the second question for us there?
Yeah, thanks, Jack. That was a great question. We see your note below very, very well. Christine, how are you seeing companies balance interest between the usual cost savings of arbitration and avoiding class actions with the California law that requires companies to pay arbitration costs? I believe DoorDash dealt with this issue of having cover costs of hundreds of individual arbitrations. I remember that.
I'm going to disclaim this with this answer and state that obviously Nicole and I are very, very focused on this one specific area of dealing with class actions. Legal spend, of course, I'm sure there's some of you that may know this better than me. Our first thought, of course, is always, if we can avoid a class action and we can avoid a class decision, we always generally want to do that. So, and the thinking that Nicole and I have there, obviously the California law I know is a problem, and especially for companies like DoorDash that have dealt with things in the context of AB5 or employment classifications and things of that nature. Generally, most of our experience in companies are folks want to overwhelmingly still stay away from class actions because of the costs and risks that are there. Many of them I know are working with various ADR providers that are scalable for them. And are generally more cost effective. And I think, you know, companies, again, I'm reading into this based upon limited conversations that I have on costs of arbitration versus the class action itself. But most of what we're hearing is still, hey, we'd much rather go the route of arbitration and swallow that pill versus the risk of going public, class action, because there are things, when I think most organizations think about this, there are costs to a class action that go beyond what we actually pay. There are brand damage issues, reputational issues that if we just settle in a private action that's kept out of public record or doesn't garner as much headlines, there's value to that as well. So, Nicole, anything else you'd add there?
Yeah, I mean, it's so, even if they're paying the arbitration costs, it's pretty much almost always going to be less expensive to do arbitration than it is to, you know, handle a class action lawsuit. Another thing to note here is usually we're looking at individual arbitration instead of class arbitration. So the chances of that whole class of consumers one by one going to arbitration with a company, super slim. They're probably not having to be involved in arbitration for very long because most attorneys, it's not worth their time to do one arbitration case at a time. So it really, by bringing it to arbitration, usually they're squashing the case altogether or vastly reducing how much they're going to pay out.
Perfect. It looks like we got a follow-up coming from Christine. So it looks like we have about 15 minutes left in the hour. I know you guys wanted to kind of run a little shorter today, but if there's any questions, we got a tight group here for the last few minutes. If there's any questions on Clickwrap agreements, feel free to jump in. Other than that, I have one other question for both Nicole and Kyle on the different use cases across the board. Like if you have financial institutions versus a tech company, is there a different use case with how a Clickwrap agreement is applied to different verticals?
Yeah, Colin. Nicole, go ahead, and then I'll jump in there.
So certain best practices that we have become even more suggested or recommended based on the industry. If it's heavily regulated like finance, it's probably better to embed the contract on the screen rather than linking it. But you know, there are certain ones where they're going to want an email sent back, that kind of thing. But I mean, when you're looking at different industries, there's different ways they can use Clickwrap too. So it goes beyond just traditional contract acceptance. You can be tracking consents, opt-ins, opt-outs, all of that kind of fun stuff as well.
Yeah, consents and opt-outs are a big one. They're all different sorts of financial consents. If you're a bank and you've got any sort of online presence, there are lots of different things that go beyond traditional TOS. That we work with a few different large financial institutions that utilize PaxSafe for that purpose to document those consents and those transactions in the same way. But, you know, Colin, there's also usage for Clickwrap agreements. You know, we see it in, sales contracting. We see it for NDAs is a big PackSafe use case that's still utilized on the B2B side. Any type of contract where we know, hey, it doesn't make sense for us to negotiate this with a certain, percentage of our customer base or counterparty base, that's a great place to implement a Clickwrap agreement. Beta agreements, test agreements, pilot agreements, all that sort of stuff that you may not want to, that doesn't really need to spend a ton of time with the actual legal team. It's an opportunity to put that in a Clickwrap agreement format and power it just through a checkbox or through one of our hosted products that actually don't require integrating with the website.
Yeah.
Cool.
And one,
sorry, go ahead.
One thing to note really quick here is we've seen success with Clickwraps across pretty much all industries. I think finance was actually the #1 industry using Clickwraps in the litigation that I read last year. We've got healthcare as well, a bunch of other industries, but those are kind of interesting, more regulated ones that are successful with Clickwrap.
Is there anybody just from a community purpose? Is there any companies that should be using them more, enterprise versus startups?
Yeah, generally we see that PackSafe is utilized honestly from startups all the way up to the enterprise. Generally, we do see companies that as they grow, they take on more Clickwrap agreements. Listen, if you're just starting out and you're a 20-person organization, I'm going to recommend that you go get an e-signature tool and maybe a very basic place to put some contracts like anything else. So there's an inflection point where a CTP or a Clickwrap product like PackSafe comes in on the growth and the maturity curve, and it's probably somewhere. If I didn't work for PackSafe, I would say it's somewhere probably just after CLM, after we've implemented CLM.
Got it. Mm-hmm. So you're saying you get your repository, you get your workflow, then come in, and that begs the question: do you guys work with any workflow tools?
Yes, so we can integrate and work with some workflow tools, and I'm going to hedge that and state that it depends upon the workflow tool.
I see it going there, right? I see what you're doing.
Yep.
This is fascinating. Thank you so much for bringing the energy today and just sharing this education with us. This is really phenomenal stuff, and I really appreciate your time and sharing this information with us. I will share a copy of this recording with the community and all the attendees today. Follow up with the slide deck. I want to thank the attendees for coming. Really, really appreciate you. And our speakers have just been phenomenal again today. Nicole, Kyle, can I give you any kind of parting words?
No, I'll just say, hey, if there's questions we can answer. If you've got a question about TOS in your consumer life, if you've got a question about an agreement that your team is using, shoot it over to us. Nicole and I are happy to be a resource. We're not just here to sell software products and things of that nature. We honestly kind of nerd out about this stuff, which might be sad, but it's our little world.
You're in good company, guys. Listen, thank you so much, and we'll be in touch again soon.
Cheers, everyone. Thank you.